Article 370 verdict is out and J&K holds no internal sovereignty after accession to India, says the Chief Justice of India. And Top Court upholds the J&K 2019 government order. Top Court says that Article 370 is for integration and not disintegration. And Mr. Kora, are you still there? Mr. Kora, for our viewers, I would just like you to elaborate on the arguments that were made by the petitioners. Could you take us briefly again through the arguments that were made by the petitioners?
You know, the first point was that petitioners, the main argument was that consent of the Constituent Assembly of J&K was required, and which was mentioned, which was laid down for any such amendment. And the Parliament could not take any action on 370 in absence of the Constituent Assembly not giving any recommendation. And to overcome this deficiency, in 2019, the definition of the Constituent Assembly was changed, and it was meant in the revised definition of the Constituent Assembly, it was mentioned that since that is not existing now, so the powers of the Constituent Assembly will be exercised by the Legislative Assembly. And because the state was under President's rule, so and therefore the powers of the Legislative Assembly will be exercised by the Parliament. So that's a natural corollary. Wherever the state assembly is dissolved, the powers of that assembly are exercised by the Parliament. So the Parliament exercised the powers. The Supreme Court held that invalid, that definitions cannot be changed like this to suit the convenience and bypass the laid-down procedure. But at the same time, the most important thing which the Supreme Court mentioned is that Constituent Assembly power to recommend ceased to exist after its dissolution. So there was no requirement to follow the procedure of getting the consent of state Constituent Assembly because it was already dissolved. So Parliament could enact the act straightway without going through the circuitous process of changing the definition and then exercising powers of the Legislative Assembly. So in a way, though that part was held invalid by the Supreme Court, but the other part, that the Parliament had the powers and Parliament powers of Supreme, and the J&K did not have any sovereignty or some sort of sovereignty different from other states of the Union of India. So that was also clearly mentioned. And in fact, it mentioned that in instrument of accession, when that mentioned clearly, because that was another point which was being constantly raised in the Supreme Court by those who had challenged this order of the government, that the powers of the Parliament were restricted. So that was also clarified by the Supreme Court that the Parliament had the last powers as far as, and it did not always go by the Legislative Assembly's views or Legislative Assembly's recommendations. And the third point which the Supreme Court also clarified is that the powers of the Parliament were not restricted to lawmaking only. As far as J&K was concerned, it was much beyond that, and that the Constitution of India is supreme, and any conflict of constitution with Constitution of India, in that case, the Constitution of India will prevail. So the things were clear.
All right, and we'll just cut across to our reporter, our correspondent, Idris. Idris, a unanimous Supreme Court verdict that holds the Article 370 temporary. What is the latest that you have on this?
Well, absolutely, especially if we talk about the local leadership, the regional leaders of Kashmir, they seem to be disappointed with the of the Supreme Court. But Supreme Court making it very clear that Jammu and Kashmir does not retain any element of sovereignty after the instrument accession was signed. There was no internal sovereignty given to the Union Territory of Jammu and Kashmir. They also said that Article 370 was a temporary provision because at that time Jammu and Kashmir was going through a war situation, and that was one of the things that it was it was basically allowed to. But now what we were expecting, at least the regional political party Jammu and Kashmir were expecting some kind of relief from the Supreme Court, as they had pinned all their hopes on the judges, on the 5 bench judges who were sitting on the case. But at the moment, there's no word from the local leadership as of now, because they are in the morning said some of the leaders like PDP as well as National Conference have claimed that the former Chief Ministers, Mehbooba Mufti, as well as the former Chief Minister Umar Abdullah, are under house arrest today. They have not been allowed to go out of their houses. But we are waiting for their official statements as well. But in general, it looks like they would definitely be disappointed with the decision that is.
Right. And now we go back to Mr. Khoda. Are you there? Can you hear me?
Yes, I can hear you.
Okay, and I would like to also ask you that the Supreme Court also said that they will be holding J&K polls that is expected to be held by September 2024, and it also called to restore J&K statehood as soon as possible. How does this pan out in the near future?
In view of the Supreme Court direction, which lays down the date for holding elections, the Government of India and the Election Commission particularly will have to initiate the process and start the process, start updating the voter lists and other formalities which are required. The Delimitation Commission has also completed its exercise, and the number of assembly seats have been raised from 83 in J&K, leaving aside Ladakh, which has 4. Previously, Ladakh was also with J&K, and that time the number of seats was 87. After those 4 were separated, it left J&K with 83. Now, the Delimitation Commission recommended raising the number of seats from 83 to 90. Then 24 seats are, of course, reserved for POK, which is part of India as per the instrument of accession, as per the law, international law also, and of course the elections cannot be held there, as has been the case previously also. So the elections for the 90 seats will be held before September 2024, which comprises of 47 seats from Kashmir Valley and 43 seats from Jammu region. And then, in addition, there are 5 nominations to be made, 2 women, 2 migrants, out of which 1 will be a women candidate, and 1 for the POK refugees who are settled in Jammu. So the process will have to start in due course. And regarding the restoration of statehood, the Supreme Court did not go into it in view of the undertaking by the Solicitor General in the court that statehood will be restored as soon as possible, and Supreme Court has reiterated that Government of India should restore the statehood of J&K as soon as possible. And Ladakh will continue to be union territory. That part of the exercise of government has been upheld. And they have cited various previous instances when the carving of states has been carried out, and where the requirement of any state legislature was not required. It happened with Telangana, carving out of Telangana also, when the state assembly that in Andhra Pradesh did not consent to its bifurcation, but Parliament approved it and it went through. So there's no change in status quo as far as that is concerned, and I think that a very positive judgment, which will put the things back on rails and clear the clouds of uncertainty over J&K. And people of J&K will move on path of progress without any uncertainty, without any confusion. Those elements who had been advocating for special status and autonomy and other divisive forces and other separatist forces, they have got final answer from the highest court of the India, and it augurs well for the entire country and for the people of J&K in particular.
Okay, now we'll cut across to Idris. Idris, what are your comments? And in your view, the Supreme Court has called for restoring J&K statehood as soon as possible. How do you think this is going to pan out?
Well, absolutely. Let me just give you a brief news that is just coming in. Umar Abdullah has just made a statement on Twitter, and he said, disappointed but not disheartened. The struggle will continue. It took the BJP decades to reach here. We are also prepared for a call. Basically, the whole political leadership of Jammu and Kashmir, especially the regional parties like National Conference as well as the PDP, are extremely disappointed with the decision. They're saying, but their fight is not over. They will carry on the fight because they want the special status of Jammu and Kashmir back. On the other side, we've also seen that the court has made it very clear for the government of India to hold elections in the Union Territory of Jammu and Kashmir. This has been, let me tell you, the longest haul in terms of not holding it in the Union for over around 9 years now. The last elections that took place were in 2014. So that is something that the government needs to work on, because the regional parties, as well as the mainstream parties of union parties, have been demanding from day one that the elections needs to be held in the Union Territory of Jammu and Kashmir as soon as possible, because democracy is extremely important for every state of India, and so that for this Union Territory of Jammu and Kashmir. We've also, the leadership of Jammu and Kashmir have been asking, especially the Home Minister, who on August 5, 2019, declared that Jammu and Kashmir and Ladakh would be converted into Union Territory. At that point of time, they made it clear that it's a temporary provision improve in both the places. The statehood would be returned. And now the Supreme Court has also focused on that and asked the Indian government that both the things. First, the elections should be held before September 2024, as well as also the return of statehood, as the government has been claiming the situation after revocation of Article 370 in 2009 has actually improved across Kashmir Valley. The number of militants, active militants in Kashmir have come down. The incidents of violence have come. That is one of the reasons that it seems like it's a proper time for the union government to decide on the return of statehood to Jammu and Kashmir as well as Ladakh, both the union territories.
All right, so for our viewers who are just joining in a landmark judgment, the CJI has delivered that Article 370 is a temporary provision. Listen in to some excerpts.
The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. The special circumstances because of the war conditions in the state. That a textual reading of Article 370 also indicates that it is a temporary provision. For this purpose, we have referred to the placement of the provision in Part 21 of the Constitution, which deals with temporary and transitional provisions, the marginal note to the provision, which states temporary provisions in respect to the state of Jammu and Kashmir, and a reading of Articles 370 and 1, by which the state became an integral part of India upon the adoption of the Constitution. The power under Article 370, Clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. When the Constituent Assembly was dissolved, only the transitional power recognized in the proviso to Article 370, Clause 3, which empowered the Constituent Assembly to make its recommendations, ceased to exist. It did not affect the power held by the President under Article 370, Clause 3. G. Article 370 cannot be amended by exercise of power under Article 370(1)(d).
And we now cut across to our correspondent Divyanshu. Divyanshu, a historic day for India. A landmark Article 370 verdict is out, and J&K holds no internal sovereignty after accession to India, says the Chief Justice of India. What are your comments and what's the latest you have on this?
Well, Rahesha, definitely a historical day. As the verdict is still going on, the conclusions are out. It says that J&K does not hold and does not retain any element of sovereignty after instrument of accession was signed, and no internal sovereignty for Jammu and Kashmir, which clearly, this was the main, challenge by the petitioner, that is this right? Is it constitutional? So the Supreme Court has clearly defined it, challenging to the proclamation of presidential rule is not valid and it's not constitutional. So again, this was one of the main challenge by the petitioners, that whether the presidential rule on Article 370 is legal or not. But Supreme Court, the court has clearly said that the challenge to the proclamation of the presidential rule is not valid. Also, the exercise of power of presidential rule must have a reasonable nexus with the object of presidential rule. So, Rahesha, a complete statement coming out from the court that the Article 370 was a permanent provision and the presidential rule is absolutely right. Back to you.
And now, Mr. Kauda, we come straight to you. Now the top court has refused to rule on the validity of the presidential rule that was imposed in J&K. Now, what do you think is going to unfold when it comes to restoring the J&K statehood in the state?
The Supreme Court has laid down the deadline for holding of elections and also directed the restoration of statehood as soon as possible. I think with that, the presidential rule will also come end, and that will settle the issue. So I think that the Supreme Court did not want to go further into that other than giving directions which will settle the issue.
And the petitioners argued that the Article 370 was permanent and could not be touched, and the government claimed that the framers of the Constitution did not intend to give it any permanent character. What do you think, what are the sentiments like when it comes to the petitioners? What do they think about the verdict at the moment?
No, petitioners, of course, will feel disheartened about it. But when it comes to the national interests, a country has to be one, every state has to be unified, and this was a step taken in the direction of completing the process of integration of J&K with the rest of the country, and being on the path of progress like other states. You know, during past few years, since the proclamation of the president's rule and also abrogation of 370, the path of development has been followed very vigorously in the state. Job avenues got increased. The militancy came down sharply. The law and order also improved. It is normal since last couple of years also now, and it showed rapid decrease in incidents immediately after the state was made into a union territory and abrogation of Article 370. All those things, you know, these things add to the general belief that the state is like any other state and it is not different, and the clouds of uncertainty are over, and let's join the mainstream. The divisive elements also got their answer that you no longer can now proceed with your agendas. The government, the union government is very clear on this. And now the Supreme Court verdict has also come that settles the issue for once for all and for everybody. So I think honoring the decision of the apex court, everybody should join hands. All those petitioners who had gone to the court, it was their right to go to the court. But now that the court verdict has come, all of them should join hands and work in the interest of the peace, progress, and development of Jammu and Kashmir. That is what the people of J&K want. They want peace, they want development, they want progress, they want industrialization, they want job creation, and they want to progress. J&K has tremendous potential of tourism, generation of hidden power electricity.
Historic day for India, indeed. A historic day for India. Landmark Article 370 verdict is out, and the top court says that the Article 370 is a temporary provision. Thank you so much for joining us, and thank you for your time, Mr. Kauda.